Good morning. My name is Jim Copeland. I'm the Chief Enforcement Attorney at the South Carolina Department of Consumer Affairs, and I'm super excited to be here with y'all today to talk about the South Carolina consumer protection laws and mechanisms in place to protect you, the consumers. So first and foremost, in true lawyer form, I have to give you a disclaimer before we get too much further. The presentation today is not meant to serve as a substitute for reading the laws that we're going to discuss or seeking legal counsel or otherwise requesting our guidance or interpretations on the laws that we administer and enforce. This presentation is merely an overview, 10,000 foot view. We could spend days talking about all of the consumer protection laws in place, but I think we're going to hit on the top large ones today. All right, so meat and potatoes of today's discussion. Title 37 is known as the South Carolina Consumer Protection Code, and the entire title deals with several aspects of our regulatory authority, consumer credit sales, consumer loans. A few of our regulated industries are found in there. Our identity theft enforcement authority is found in there, mortgage lending, and as well as unconscionable debt collection. Also, a few things that we're going to touch on today is the department, through its authority in the code, also has authority to implement and ensure compliance with some federal laws. Those laws would be the Federal Truth in Lending Act, TILA, as most people know it, Fair Debt Collection Practices Act, the Fair Credit Reporting Act, and other state and federal statutes that are enforced by the department. And those would be things like our pawnbrokers, our pre-need funeral contract providers, things like that that are just found scattered throughout other titles in South Carolina law. So where does the Consumer Protection Code apply? So these laws, of course, are designed for consumer protection. So they don't apply to non-consumer transactions. Makes sense, right? A lot of folks wonder, what is a consumer transaction? Well, first and foremost, a consumer transaction has to be entered into by an individual person for a consumer purpose, which is a personal, family, or household purpose. So if you go and buy a truck for your business, that's not a consumer transaction. If you go and buy a truck to drive your family to the beach, that is a consumer transaction. Also, a transaction that would be entered into to make money, for example, investments, or for some other business purpose, buying a building to open up a law firm, things of that nature, just not a consumer purpose, even if you have to guarantee it personally. A little bit of history on the Consumer Protection Code. So prior to the Consumer Protection Code, little protection, if any, existed for consumers in the marketplace. Our Consumer Protection Code here in South Carolina was adopted in 1974 and became effective January 1st, 1975, which is when the department opened. Major amendments have been made to the code in years since, in 76 and 1982 and in 1999. And then many minor amendments have been made over the years also. Our code is a version of the Uniform Consumer Credit Code, which as funny as it sounds, we call it uniform, and other states do have a version. There's, I think, 10 or 11 of us. Colorado, Maine, Indiana, Oklahoma are a few that have versions of the uniform code. Now, as you can imagine, the General Assemblies in all states are a little different. So there are some intricacies in each state, but generally speaking, any state that has a version of the Uniform Consumer Credit Code will have a lot of the same protections, requirements, and prohibitions. So the purpose, we have a list of purposes that are set out in statute as to what the purpose of the Consumer Protection Code is. Basically, some important ones are, although they're all important, some of the more important ones are to simplify, clarify, and modernize the law governing retail installment sales, consumer credit, and usury in South Carolina, which we'll get to in a minute because we're not a usury state. To provide rate ceilings to assure an adequate supply of credit to consumers. We also to protect consumer buyers, lessees, and borrowers against unfair practices by suppliers of consumer credit. And we always have due regard for the interest of legitimate and scrupulous creditors. We always try to balance, balance the interests of both the businesses that are behaving themselves as well as consumers. Now, a few interesting things. There are, important to note, some exclusions from coverage under the Consumer Protection Code, meaning there are just some things that are not governed by the Consumer Protection Code, meaning there are no protections for transactions such as these under our Consumer Protection Code. First and foremost, extensions of credit to the government or governmental agencies are not consumer transactions and are not covered by the code. Agricultural loans make sense, are not consumer loans, so they would not fall under the protection of the consumer code. A big one here are student loans backed by government supported programs. So think of federal student loans are not considered loans or not considered covered loans under the South Carolina Consumer Protection Code. Now, there are a lot of other federal laws that issue some protections, but South Carolina's Consumer Protection Code does not apply. Also, federally chartered credit unions. Now, I just want to touch kind of briefly on a couple of the filings that our registered creditors have to go through, just because you might hear me speak of them throughout the presentation. First and foremost, in South Carolina, any creditor who has a volume of business that exceeds $150,000 must file a credit grantor notification with the state of South Carolina. Basically, this puts the department on notice that, hey, this creditor is in the state and is offering credit. Secondly, our maximum rate filings, and this is usually going to garner a lot of discussion, but our maximum rate filings, creditors in the state of South Carolina intending to charge an annual finance charge that exceeds 18% in a consumer credit sale must also file a maximum rate schedule. Now, this is important to know because in South Carolina, we do not have an interest rate cap, meaning that creditors can charge whatever interest rate they want so long as the business complies with the requirements of the maximum rate schedule. Means they have to tell us what they charge, they have to post what they charge in their business so that you, the consumer, can know what their interest rate is before you get charged that interest rate. And this all happened back around 1982 was when South Carolina decided to deregulate the interest rates. Believe it or not, we're one of only a couple of states anymore that do not have an interest rate cap. Another term that I'd like y'all to be aware of is a supervised loan. Supervised loans are governed by Title 37, and they are kind of the bulk of what we see in South Carolina for small dollar loans. And if you see the little pictogram over there off to the screen, that we have this kind of big subsect of consumer loans, and then supervised loans, and then a restricted loans. Now, a supervised lender is a person who is authorized to make supervised loans, which means that any lender that wants to charge over 12% that's not a depository institution has to get a license from the South Carolina Board of Financial Institutions. Another type of loan that folks are familiar with are legally called short-term vehicle secured loans, otherwise known as title loans. Now, title loans are important to kind of distinguish because title loans, by legal definition, are a short-term loan, meaning that it is a repayment term of less than 120 days, and that loan is secured by the title to a motor vehicle. Now, an interesting protection for consumers in these title loans is that if it is legally a title loan, meaning less than 120 days, that if the borrower defaults, then the lender's sole remedy is to seek repossession and sale of the vehicle and cannot pursue any deficiency. Meaning, if you don't pay your loan back, they will come and repossess and sell your vehicle, but you would not be responsible for any deficiency balance as you would in, say, a credit sale or a other supervised loan for the purchase of a motor vehicle. Also, lenders have to provide certain notices to the borrower because it is such a higher interest loan. They have to say, hey, this is a high interest loan. You need to go to another source if you have the ability to borrow at a lower rate. This is, meant to be short term. Also, borrowers have the right of rescission and can repay the principal amount borrowed without interest at any time until the close of the business day following the date the loan was executed. All right, so now truth in lending. I haven't seen any questions yet. Let me just double check. Bear with me, folks. All right. Okay. So truth in lending, otherwise known as TILA, is a federal law and is found in Title I of the Consumer Credit Protection Act of 1968. Primary purpose of this act is a disclosure purpose, meaning that the act requires creditors provide meaningful and accurate disclosures of credit terms so consumers can compare and make informed decisions about the true cost of credit. And I'm going to show you here in a minute what that looks like. I'm sure all of you will recognize it the second you see it. One major requirement of this act, and also that assists consumers in shopping for credit, is that all creditors, upon the passage of this law, have to calculate interest rate the same way. Prior to the requirement, different creditors calculated the interest rate using all kinds of different methods, which understandably cause confusion when a consumer, when you or I tried to walk into store A and figure out what a loan was going to cost us, and then go across the street to another lender, and it was easy for lenders to calculate them differently and confuse consumers. So the TILA form was born. And I'm sure that you all have seen one of these before, because in any credit sale or in consumer loan transaction, you will see one of these forms. Real quickly, we'll just go through each row, because each row provides some very important information. Row 1 provides information about how much the credit is going to cost you. That's probably the most important one. Row 2 tells you whether you have the right to an itemization of the amount being financed. Row 3 provides basic information about the loan. So that's going to be, how many payments, how much your payment's going to be when the first payment is due. Row 4 is going to inform consumers whether credit insurance has been purchased and its cost if purchased. Row 5 informs the consumer whether you are giving a security interest in the goods or services being purchased. For example, if you saw this in a car contract, you would be giving a security interest in your vehicle. Row 7 there informs whether or not she will be entitled to a rebate of an unearned finance charge. So that's your prepayment. Now in South Carolina, there's a prohibition on prepayment penalties. So that box, now since that's a federal form, you'll see both options. But if you are borrowing money or financing goods in the state of South Carolina, that box should always be checked. No, you will not pay a prepayment penalty. And of course, row 8 is where the consumer signs to basically confirm that they were given those disclosures. Another interesting thing about South Carolina is, because we deregulate interest, there are a lot of other charges that the title limits creditors in taking. Okay, so for example, late charges. Late charges in South Carolina can be 5% of the installment payment up to a statutory maximum, which changes every other year. Now, it changes based on a consumer price index, and we publish those on our website, but that's a little too in the weeds for our discussion today. But you'll see my little black highlighted portions here of the chart, and those are the changes that are most current. Say, for example, your installment payment was $200, multiplied by 5% is $10. So the maximum late fee on an installment payment of $200 is $10. Now, let's say your installment payment was $500. Now, 5% of $500 is $25, but in South Carolina right now, the maximum late fee is capped at $23. So, because 5% exceeds the maximum allowable interest or the maximum allowable late fee, a creditor can only charge you $23 for a late fee if your installment payment is $500. Now, there is a little caveat, of course, with most statutes, that there is an exclusion. Now, creditors can contract for a minimum late fee of 40% of the maximum. Now that's a real complicated way of saying that they can contract for a minimum late fee so long as it does not exceed the minimum late fee by statute. This case for the next 2 years is $9.20. Okay, so oh, sorry guys, thanks for bearing with me. We got a good question, and it's why are lenders allowed to stop credit and disability insurance at a certain age? What happens to the balance when the person dies? Huh, that's a really good question, and I'll probably have to look into that because I am not familiar with lenders stopping credit and disability insurance. I do know that generally in unsecured transactions, when someone dies, that the creditor has a right of claim against the estate of the borrower. But let me look into that answer and I'll get back to the person who asked that question because I've never been asked that question before. That's a good one. All right, so in South Carolina, folks, here predatory lending laws. In the state of South Carolina, really the only predatory lending law we have is the High Cost and Consumer Home Loans Act, which basically deals with mortgages that are more than 8 points higher than a U.S. Treasury note, and the upfront points are more than 5% of the loan amount, which when that kicks in, no balloon payments are allowed more than twice the average of other payments. Okay, so next kind of batch of consumer protection law is Chapter 7 of the Consumer Protection Code, and it's dealing with consumer credit counseling. So it requires that credit counselors maintain a license from the department and probably requires the definition of a credit counseling organization. In South Carolina, we include all three, really what's understood as credit counseling services. We consider all three requiring a license in the state of South Carolina. So those companies that do debt management plans, those receiving money to improve or offer to improve a consumer's credit record, and those folks that do debt negotiation or settlement or like foreclosure assistance all require a license, and their fees are all capped, as you can see by the charts here. Debt management plans are capped at an initial consultation fee of $60, plan setup fee of $50, and a monthly maintenance fee of $10 per creditor, not to exceed $70. Credit repair is similar, and debt settlement, as you can see, is similar also. Okay, Fair Credit Reporting Act. And guys, I know I'm throwing a lot of these at you, but it's hopefully kind of gives you just a touch and go on all kinds of different laws that you should be aware of as a consumer in the state of South Carolina. The Fair Credit Reporting Act. is a federal law. It's designed to promote the accuracy, fairness, and privacy of information in a consumer's credit report. And it defines rights for victims of identity theft, including when a company is attempting to collect a debt arising from the identity theft event. The Equal Credit Opportunity Act prohibits credit discrimination on an improper basis. It does not guarantee that a consumer will be granted credit, but if the consumer meets the creditor's tests of creditworthiness, then it requires that creditor to apply all of its creditworthiness tests in a fair and impartial manner. Hot topic item in South Carolina, our lemon law. So get a lot of questions each year on South Carolina's lemon law. It provides certain protections for consumers who purchase new automobiles, and that's important. It has to be a new automobile. Used cars do not qualify under the South Carolina lemon law. Issues with the vehicle must occur within 12 months or 12,000 miles, whichever is first. And like I said, it's limited to new passenger vehicles and motorcycles. So the living portions of RVs are excluded and any off-road vehicles are excluded. All right, on the topic of used cars, the Federal Trade Commission's used car rule. If any of you have purchased a used car recently, you should have seen this in the window, as it is required by federal law. Must appear in the window on all used cars, and basically explains to the consumer right up front, without even having to speak to anybody, is the car being purchased as is? Is there any kind of dealer warranty? Now, this does not include service contracts, because as you'll see down kind of in the bottom third of the window sticker, there is a separate box for service contracts, which in South Carolina are kind of distinguished from warranties. I know a lot of folks use the terms interchangeably, but an extended warranty is not necessary. Well, let me back up. A service contract, otherwise known as an extended warranty, is not necessarily the same thing as a dealer warranty or a manufacturer's warranty. Okay, some new rules on solar that went into effect year before last in 2021. A renewable energy facility now must provide certain disclosures when they offer their items for sale. This includes solar, thermal, wind, geothermal, biomass, any kind of renewable energy facility in the state of South Carolina. As of 2021, the companies that are offering renewable energy items have to provide two types of disclosures to South Carolina consumers. First, they have to provide a marketing brochure, which is what you see on your screen here. Basically, these are brochures that are created by the department to kind of give the consumer some topics right up front before they sign. Hey, these are the things that you need to be sure that you understand before you sign. Now, during the negotiation process and the signing of the agreements, the company is also supposed to include the standard disclosure, which basically in a high-level period or a high-level perspective shows exactly what the consumer expects to pay and to save, as well as whether there'll be any kind of warranties or who to contact when you have a problem with your renewable energy generating facilities. Also, there are certain rights of rescission. So if a contract is presented to consumer, if that consumer is 70 plus years old, then you ask, did the consumer initiate contract or contact? And then there are certain requirements basically that the company has to go through to basically give a consumer the rights to cancel that contract. And I'm just going to leave that up for a second, let y'all. Okay, another hot topic in the state of South Carolina, one that we get a lot of calls and complaints, is debt collection. Which debt collection is the process of pursuing payments of debt owed by individuals. Now, it's important to note that basically if you have borrowed money for anything, then you owe a debt. Now, that debt may not be in collections or might not be past due, but the word debt itself is not necessarily a bad word. Now, debt collection is the process of getting folks to pay their debts, whether they be current debts, past due debts that are in collections, etc. They are generally carried out by organizations that specialize in collecting debt or collection agencies. They act as agents of the creditors. Now, in South Carolina, original creditors can be a debt collector. Third-party debt collectors or debt collectors, attorneys can be debt collectors, debt buyers can be debt collectors. I have a little asterisk beside original creditors because in South Carolina, original creditors are considered debt collectors, but under the federal law, original creditors are exempt from the Fair Debt Collection Practices Act. So, the South Carolina Unconscionable Debt Collection Practices Act is found in Chapter 5, Title 37, and is part of the Consumer Protection Code, and it applies to all creditors, and it provides consumers protections against unfair methods of debt collection here in the state. Also, the Fair Debt Collection Practices Act is the federal law that a lot of places they mirror one another, except for the fact that in South Carolina, an original creditor is subject to unconscionable debt collection practices. So, some of the rules: communication with debtors includes phone calls, mail, emails, and text messages. Contact is only allowed between 8 a.m. and 9 p.m. in the time zone where the consumer is located. You cannot call repetitively in a 24-hour period. A debt collector can't. Also, under the federal law, you cannot contact a debtor at times known to be inconvenient. For example, if you have notified your creditor that, hey, I'm working from 8 until noon and you can't call me then. If that's on record, they can't call you then. They also cannot contact someone known to be represented by an attorney. The newest revisions to the Fair Debt Collection Practices Act went into effect October a year ago, and we call it the 7 and 7 rule, which means a debt collector cannot call a consumer more than 7 times within 7 consecutive days or within a period of 7 consecutive days after having a telephone discussion with a debtor in connection with the debt. And that applies to each and every debt. Of course, excluded are calls where debtor is given prior consent to call and calls that don't connect to the dialed number. Also, communications with third parties are generally prohibited, except that a creditor can contact third parties for like location purposes, home address, work address, or a phone number, but they cannot indicate consumer owes a debt. And of course, they cannot harass any consumer. They may not use threats of violence or harm, use obscene language, repeatedly use the telephone to annoy someone, or publish a list of consumers who refuse to pay their debts. Debt collectors also cannot make false statements. They can't threaten to sue you unless they are able to sue you and are planning to sue you. And they definitely cannot imply that you have committed a crime, because paying your debts is not a crime. Prohibited, unfair, these we've gotten through. Stopping contact at work. So in order to stop contacts at work, a debt collector or a debtor or their employer must send a written request to cease contact. Creditor must then stop contact. Please remember, though, to make sure you send the request certified and return receipt requested so that you can prove that they got it. Stopping contact at home. This is a FDCPA protection only, so it only applies to third-party debt collectors and not original creditors. But if it's a third-party debt collector, then you can send a written request and tell them to stop calling me at home. The FDCPA validation and dispute process is something that we also get a lot of questions on. A debt collector, in their first communication or within 5 days of that contact, must send you a notice that contains the amount of the debt, the name of the current creditor, the name of the original creditor, disclosures, certain ones like that they have 30 days to dispute or the debt is assumed valid. Also, the debtor may dispute that debt in writing. Now, collection attempts have to stop while the creditor seeks verification. Now, the new changes kind of specify what this validation must contain. It has to contain one of the following itemization dates: the last statement date, the charge-off date, the last payment date, the transaction date, or the judgment date. So there are some other South Carolina debt collection mechanisms. If a consumer defaults in a consumer credit transaction, meaning they either put the collateral at risk or they fail to make the payments, then the creditor must send a right to cure. It's sent after 10 days in default, meaning you owe your payment on day one, like say the first day of the month, you owe your payment. You didn't make your payment. It has to be late for 10 days. So days 2 through days 2nd through the 11th are late. And then on the 12th of the month, the creditor can send a right to cure and say, pay the default within 20 days, or we're going to repossess your vehicle. Now, a lot of folks ask about this as well. How many right to cure letters must be sent? And say like an auto loan, a closed-end credit account, only one has to be sent the entire life of that transaction. Now, if it's an open-ended credit account, then they have to send one every 12 months. It has to be sent to the consumer's last address on file, and important that consumers update creditors with any address changes. So, repossession, hot topic also. There's voluntary repossession and self-help repossession. Voluntary is when the consumer willingly returns the collateral back to the creditor. Now, they will still be a repossession on your account. It just, you will not incur the costs of if they have to send a tow truck out there to get your vehicle. Now, in self-help repossession, the creditor cannot take any action that may lead to a breach of the peace. And a claim and delivery action in court begins with a summons and a complaint, as well as a demand for immediate possession of the collateral. However, the consumer has a full 30 days to file that answer. And then if the judge rules that the creditor has a right to see or has a right to that property, then the sheriff can come and take possession of it immediately, even if it is in your home. Another hot topic is the statute of limitations. In South Carolina, creditors can bring a court action to recover debts only for a prescribed period of time. And I think this might catch a question over here. Yep. The question is, what recourse if the debt has been over a certain number of years? All right, so this is going to answer that question. In South Carolina, statute of limitations for contracts, generally it would be 3 years for unsecured transactions. Now for mortgages is 20 years. Judgments are 10 years. Now what's important to note is that clocks can be restarted in certain situations, but the statute of limitations only means that a creditor cannot sue you for that debt after the statute of limitations has passed, which means a debt collector can try to collect the debt until the cows come home. If you have borrowed money at some point in your past and did not pay it, then you could feasibly have a collector trying to collect it forever. Now, if it's been more than 3 years, they can't sue you for it. And if it's been more than, I think, 7 years or so, then it will not appear on your credit report, but they can try to collect it until the cows come home. So I hope that, and let me just check to make sure I didn't get any other questions.
Hey, Jim.
On that. Hey, Bailey.
Hey, sorry to kind of come in, but what I'll say about the credit report, because I give the credit reports and scores presentation all the time, and I get this question about the statute of limitations and the general idea of, well, if something drops off my credit report, that means I don't have to pay it anymore, or debt collectors will suddenly stop calling me. And it's just simply untrue. If the debt is yours, the debt is yours.
Right.
You still technically have to pay it. And like you said, debt collectors can continue to call you until the cows come home. What I will say, you did say the clock can be restarted in certain situations.
Yes.
That means if the clock is restarted, it will come back on your credit report. So if you decide to make a payment, say you decide to make a payment on that student loan you haven't paid in 10 years, or whatever other loan, that clock now restarts. Or say one debt collector sells it to another debt collector. That could potentially restart that clock, and that loan can reappear on your credit report again. So just keep that in mind. Just because it disappears off your credit report doesn't mean it's gone forever. I just wanted to point that out.
No, great clarification. Thank you. And I think that hopefully cleared up. I'll see if that garnered any questions, and not seeing any. Great. Thanks, Bailey. Yeah, good clearing up. All right. So I know I only have a few more minutes, so I'm going to try to get through the rest kind of the slides here, but I might skip a few. So I wanted to touch on reverse mortgages. It is a complex home loan. You have to be over 62, and it requires substantial equity. So basically, I just wanted you to be aware that they do exist. They're out there. They're expensive loans. Just make sure you read and speak to any of your professional tax advisors or money advisors before you consider reverse mortgage. And Bailey, I'm a minute over, so I am sorry, everyone. With that, I can't thank y'all enough for joining us. I apologize for going over, but thanks again, and hope you have a great rest of your week.